We posted a A7 amendment, and we're hoping it is received a little better reaction than the A6. I'm sure that there are those that want to testify. I understand that Mr. Rogan from the Hennepin County Attorneys Association wants to testify, but if maybe Mr. Gehring might want to briefly go through the A7 amendment. Basically, what we're trying to do is, in response to the testimony in our last meeting, set up a provision whereby there would be a mandatory letter of reprimand, which would then trigger disclosure of the bad actor, if you will. We've dropped off the provision of all systems having audit trails, and would look for some input from IT on an effective date on requiring state systems to have audit trails. And Mr. Gehring, if you just want to briefly go through what the A7 proposes.
So, Madam Chair, the A7 amendment has three parts to it. On the first page in Section 1, this is adding to the existing procedure for an individual subject to challenge the accuracy or completeness of data, to add a new allowance for an individual to challenge a government entity's access to the data. The individual will be able to provide a written notice to the responsible authority stating the grounds for believing that the individual's private data was accessed in a manner not authorized by law. And the government entity would have 30 days to respond, either to justify the government entity's access by describing the purpose for the access and the statute that authorized the access for that purpose, or to notify the individual of a breach in the security of the data, and then they would be required to proceed as required by 13.055, which is the data breach section that's being amended in the bill. The second part of the amendment is on page 2. This is lines 2.15 to 2.20. This is adding to the penalty sections of the section of the Data Practices Act, providing that any public employee whose conduct constitutes an unauthorized acquisition of not public data is required to be issued a letter of reprimand for that conduct, and that the letter of reprimand wouldn't prohibit other penalties that might be allowed by that section or any other law related to the conduct. And there's a clarification that the issue of a letter of reprimand doesn't limit any rights of appeal or grievance procedures that the employee would have pursuant to law or their labor contract. And then finally, the third section, starting on line 2.23 of the amendment, is an amendment to section chapter 16E, which is the minute chapter. There's existing language in that chapter that requires the state's chief information officer to include cybersecurity systems whenever they're implementing a new data or computer system in the state. And this would add language to that section requiring that the data security system include the capacity to audit access to not public data maintained by an agency, which would include tracking identities of individuals who access not public data and the purpose for which the access occurs.
Thank you. Any questions by members?
Madam Chair.
Representative Hillstrom.
Thank you, Madam Chair. So in my job as a prosecutor, I look up someone's criminal history on Minsus. I look at both the public portions and the private portions to look for prior criminal charges, prior information that would be used for enhanceability of other crimes. So every time I access that private Minsus that I use as part of my job, I would need to log that I looked, what I looked at, and why I looked at. Is that what this amendment is saying?
Representative Hillstrom, we don't require any log in this. I'm assuming that in that instance you would have a case number that had the data subject's name that you were working on, an investigation of sorts, and so if a data subject came to your office to look for, to find out who'd been accessing or the purpose of the access, if it was part of an active investigation, that information would be confidential. And I don't know all the nuances of your job, so I'm just talking from the 10,000-foot level. And so that information would then not be private data but confidential. And so at the completion of the investigation or whatever, there would be not a disclosure of you as the person, but that there was access to the case as a result of an investigation under whatever statute that authorized that. And only if that was determined that information was accessed without authorization would there be then a process where you as the employee could exhaust any appeals or grievance procedures through employee process, and at the completion of all of that, if it was found that you did access information without authorization, then you would get a letter of reprimand, and your identity then would be able to be known to the data subject. And so in not every instance is there going to be audit trail or information, and so if it's missing, you can't really disclose it. So in other words, these instances where we heard in the testimony, if I open a file that has 300 names in it, there's no audit trail of that. There's no ability of a data subject to find out any information in that case.
Madam Chair.
Yes.
The reason why I'm asking is because, so as I'm doing my work, for example, if I happen to be working on a case that's Tom Smith, and there's 500 Tom Smiths,
right,
or I transpose a date of birth, right? I might look at somebody's data that I inadvertently was looking at because there are too many Tom Smiths.
Right.
So my question really is, though, how do I then log or keep track or disclose or have the information so it can be disclosed that I looked at 12 Tom Smiths before I figured out which Tom Smith it was that I really was looking at because the paperwork had different dates of births or different middle initials.
I don't view that this language has any requirement for additional data collection for beyond what's being done as far as logging and access. To the degree that it's available and somebody in the course of an investigation could determine it, then then you would have a response or a resolution of the request for whether or not it had been accessed inappropriately. But if there's no audit trail, if there's no ability to find that out, you can't make something up out of thin air. So, any other questions? Senator Dibble.
I think Representative Hillstrom asked an excellent question, and I think the response is hopefully you're keeping track of the work you're doing. I think, for example, if you look up 2,500 Tom Smiths and a little alarm bell or something goes off and someone asks, why are you looking up every Tom Smith? You say, well, I'm trying to find the right Tom Smith is the answer, and I think then the matter is settled.
I'll listen to the testimony.
All right, thank you. Mr. Rogan. Welcome to the committee. If you'll state your name for the record, please.
Thank you, Madam Chair. My name is Dan Rogan. I'm the Civil Division Manager of the Hennepin County Attorney's Office. Thank you for allowing me to testify. As you may recall, I was here last week, and I appreciate that the A6 amendment is now replaced with this A7 amendment. So thank you for that. Second, I just want to kind of preface my comments, as an advocate for Hennepin County and in the County Attorney's Office dealing with these issues. As an advocate, my preference would be to kind of limit as much as possible, the type of legislation that we're contemplating here today. But I understand the role that the legislature has and the direction here. And so what I really want to do is to try to highlight what I think are some of the concerns with the A7 amendment, recognizing that there's a side-by-side. I think there's some tweaks that I'd like to see about that. So first of all, just with the A7 amendment, the provision I wanted to first talk about was the requiring a written reprimand, which was mentioned. It's in lines 2.5 to 2.20. And as was referenced, this will require a written reprimand for any employee whose conduct constitutes unauthorized acquisition of not public data. I think this is an unprecedented provision. As far as I'm aware, the legislature has never dictated specific discipline for an employee. That's traditionally has been left to the employer to determine discipline. As I said, I'm not aware of any. I could be mistaken on that. And pursuant to PELRA, all collective bargaining agreements in the state require that there's a provision that employees have the right to appeal and arbitrate discipline. So under this provision, we, the county, may be arbitrating written discipline that we may not believe is needed, we may not believe is something that is required based on looking at all the circumstances, but simply because there was an unauthorized acquisition of not public data, the arbitration will really be over whether or not the legislature's imposed discipline is appropriate and not the employer, which causes, I think, some due process concerns for employees. I do appreciate the fact that it does have a sentence in there saying it doesn't limit the appeals process, and so that can go forward. But I think it certainly creates an odd dynamic for collective bargaining agreements and the provision on that. I really believe that employers should be able to consider all factors when deciding on discipline, including any mitigating factors. And then, so finally, I think that that provision creates now 3 different tiers of possible penalties for unauthorized acquisition. Under 1309, this is kind of in the side-by-side A and B, and then this adds C. If there's a willful violation of the Data Practices Act or knowing access, that can be a misdemeanor. If there's a willful violation, right now it says it's just cause for suspension, and now we're adding, even if there wasn't intent, but it's unauthorized acquisition, we're going to have a written reprimand. So I think it's a significant shift in how we're dealing with employees, and I think, in my estimation, I think it goes too far, and the legislature should really allow employers to make the decision about how and whether to discipline. The second point I wanted to make is on the second provision, or the other provision, that the new process on challenging whether access was legitimate. And Representative Holberg, you had asked me about that at the last meeting, and I said I wasn't sure. I hadn't really thought about it, and now I see you have thought about it, and here we are. I want to raise a couple of concerns I have about it. I think there is a way to have something like this, but I think that the current version is concerning for me, and I'll just raise the concerns. First, I do think that we're trying to create an administrative remedy where I don't think one is needed. Under current law, someone can bring a lawsuit right now for unauthorized access to their data. They can bring a lawsuit and say, Hennepin County violated my rights when they accessed my data. We've seen it in the DVS cases. We've seen it in others where people are not only bringing claims under state tort law, but they're actually bringing claims under the Data Practices Act. And if access was improper and the individual was damaged, they're entitled to recover damages. Second, then, this kind of goes back to, what are we really deciding in this administrative process? And really what we're deciding on the access part is was the employee's access legitimate or not? And so we're really kind of getting back into an employee-employer analysis about whether or not the person should be disciplined. And in the normal case, if we determine there isn't sufficient evidence of a breach, then the employee is not disciplined. And under this, it shifts the burden to the government to come in to try to produce sufficient evidence to try to show that the burden, that it was legitimate. And so whether or not it actually requires logging data, that's going to be something that's going to be a concern for government to try to make sure that we have sufficient evidence to try to show in the examples that Representative Hillstrom talked about, when we're looking up people who may not be the person who's on our file but are related somehow, that we have a mechanism to track that so that if that person subsequently challenges the access to it, we have some way to look back at why we thought that was appropriate. Third, sometimes we access private data, like the DVS data, like criminal history, like child protection data, as part of a civil or criminal investigation. And the reason that we access the data is for this new purpose. But we access private data, so we're not accessing. So it's not the creation of the new data, but it could be. I'm a law enforcement officer, and now I've looked up 3 people in DVS because I want to know, because I think that they're suspects, or I think that they might live near the suspect, or whatever the specific reason is. The DVS database is private data, and they can request access to that. And now, as a government agency under this provision, when they say we want to know what the reason was for your accessing that data, we now are obligated to disclose it, which will force us to disclose the investigation itself, whether it's criminal or civil. So it even though it tries to carve out saying that we're only accessing private data and we're not going to be dealing with confidential information, the way that it will work in real practice will be we will have to disclose the reason for our access, which could be that somebody's under investigation. So I think it causes significant concern for us being forced to disclose confidential civil or criminal investigative data.
Mr. Rogan, but isn't that the case right now when a data subject wants to find out what information is being held on them, that if it's not part of an investigation, they get access? If it is being investigated, then they get the response that it's confidential? I think right now it works that way as far as access to the information.
Madam Chair, yes, in part. We have to disclose. So, for example, my DVS example, if somebody requests I want to know from the state what entities have looked me up right now, the DVS, the state will say, you were looked up 4 times by Hennepin County. What is not required is then the person going to Hennepin County and saying, I want you to explain why you looked me up. And if the explanation is it's a sheriff's deputy who is investigating this person for a crime, we don't have to disclose that right now. There's no obligation to disclose the reason that we access the private data. What this language will do is force us to explain why we were looking at the data. And in many instances, the reason that we're looking at the data is confidential. And so even though we're accessing private data, the reason that we're accessing it is confidential. So this is a new provision that I think will limit the ability for us to assert, we're not going to tell you anything about it because that has the possibility of disclosing confidential information, which by itself discloses maybe I'm under investigation. So I think this provision adds a new wrinkle that currently isn't there. Right now we have to disclose that the subject, the private data was accessed if we have a record of that. But what we don't have to do is explain why, and that's what this provision does.
But, Mr. Rogan, it's kind of like when you call the hospital to find out if somebody's there, and if they're not there, they say, no, they're not here. But if they are there, but they haven't had a release of that information signed, they say, we can't give you the information. If you're a data subject and you're requesting information that's being held by an entity, say Hennepin County Sheriff's Office, you go and you say, I want to review the information being held by the Hennepin County Sheriff's Sheriff's Department. If it's private, you get it. If it's under investigation, they say there's confidential information and you can't have it. So that same nuance occurs right now in finding out what information is being held.
Madam Chair, it does, except that we don't. What this is going to require is us to explain why we access the data. So under the scenario right now, you're correct. If somebody asks the sheriff's office, the way that we would respond is, here's the public and private data that we have about you, and that's it. And we would, if they were under investigation and there were a bunch of police reports that were confidential investigative data, we're not going to disclose that we have those, or well, we have to disclose if they have other data, we have to disclose that, but we're not going to disclose the nature of those. We're going to say you're the subject of data, and here's all the public and private data about you. But if they go the next step and say, I see that you accessed this private data about me pursuant to this new legislation, what's the purpose for you doing that? Now I have to disclose what the purpose was. And I don't have the ability to say, I'm not going to tell you. Because right now it says I have an obligation to do it, and if the data subject isn't happy with it, there's an appeal process, and I have to explain, and I have the burden to explain why we access that private data about them. So it does require us in those instances to be disclosing the nature or that they are at least the subject of an investigation. So I think that's a problematic provision of this. And then fourth, another argument, and I just have a few of these, I'm sorry.
That's okay.
The way that the language is written right now is it simply requires someone to believe that their data was accessed by a government entity. And so right now the provision that this is a subpart of, we know when somebody says, you have a piece of data about me that's wrong. I know I have the data, I think it's right, the data subject knows that I have the data and they think it's wrong. So there's a clear dispute, and we can go to an administrative process where someone can determine whether or not the data we have is correct or not. Under this provision, there's no trigger to determining whether or not the individual's belief that the access was improper or that there was access is based on any evidence. What if we say we didn't access it? You come in and say, somebody showed up at my house, you must have accessed my data. And we say, we look at our records, and we don't have any record that anybody accessed it. Now we have an appeal process where we're stuck trying to say we didn't access it. They're saying we accessed it, and there's no evidence for it. So, in other words, it's not really limited to cases like DVS where there's an audit trail where somebody says, here's the evidence that you looked at. If somebody looked me up on December 5th, and I think that was improper because it was somebody from Coochin County, and I live in Hennepin County, and I can't imagine a reason for it. And then you could have a process. There's no trigger here for saying there's an audit trail. There's evidence that somebody looked it up. And so I think that puts us in this conundrum of trying to create data so that we can ultimately later justify what we did, so that we can come in and say, well, we would have done an audit there would have been an audit trail had we done it. So I think that there might be ways to deal with that the way that there are in 13085 dealing with when there are challenges to when government says we don't want to give up data, and there's an OAH process and there's a probable cause finding. There might be other ways to deal with that issue to try to root out the cases where they're not going to be something that can be either reviewed or that they're not something that there's going to be access on. And then another point, as Representative Hillstrom pointed out, it forces us to justify why we access the data. And in many instances, we have people who are accessing data for reasons that aren't related, that are related to something that they're working on, but are not the named person on their file. And so we've experienced this in the DVS cases where we've looked back. At cases that data access from 5, 6, 7 years ago, where we go to the employee and say, you've looked at this. What was the purpose? And it's so long ago. They say, well, I don't know. Was their brother on probation? Who lived at the house? I can't remember. And so it's forcing us to kind of disclose this to try to track this data or to be able to reproduce a reason why, when in many instances we're not tracking that specific provision. So I think that this provision has some significant problems. However, if this is going to be included, some type of this process is going to be included, I think it needs to be limited to cases where the question is whether or not the access was legitimate. In other words, we're not going to be fighting about whether or not there was access, because there's going to be many instances where we're just going to say, we don't know if we accessed it. If somebody told me right now, you must have looked up my child protection records on the Maxis system, there's no audit trail for that. I'm going to have no idea about how to prove that. And so I don't think that we should be getting into disputes about whether or not it was accessed. I think if it's going to be in here, it should be really about the cases like the DVS where there's at least an audit trail, where there's some evidentiary burden that's been met to make it so that all that we're disputing about is whether the access was legitimate. And I think, second, I think it should be part of 13085 and some of the procedural elements that are in that, which include a 2-year limit, that the access for the, right now, if you want to challenge, you ask the government for data, they won't give it to you for the reasons that they say. You have 2 years from that time to bring a proceeding. And so we don't get stuck trying to litigate things that are happened many, many years ago, where it's going to be much harder to prove that. And then I think also some process where the OAH makes a probable cause determination to proceed, so that we don't end up litigating a lot of these cases. We try to come up with an expedited process where we can root out a lot of the cases where I think that there's not a legitimate basis for it. Then just moving on to the additions to Section 16.03. I think this is probably along the lines of what I was suggesting last week, is coming up with some kind of a provision where the legislature would really try to impose an audit trail on new systems. And I've looked at the legislation. I'm sure the state will talk about it. But the concern that I had was that it only applied looking forward. That it gets added to the plan for new systems. That we don't create some obligation where it mandates that all these systems have this audit trail right now. I think that would be a significant burden for the state, and I'm sure they can talk about that. But often what happens is, when there's a state-imposed requirement on some of these things, they'll require us by contract or otherwise for counties to comply with that. And so I would just want to make sure that what the intent here is, which it sounded like the way it was described, was that it's in the plan, and that when we purchase new things, that we're buying things that have robust audit requirements, because I think that is legitimate. I just don't want it to be something that in 2014 we're trying to scramble to deal with.
Mr. Rogan, I think I stated that in my opening remarks, so we'd be looking for MinIT to provide some direction as far as an effective date or process, where RFPs issued after a certain date or systems installed after a certain date. Perfect. Or whatever. Great,
thank you. Just two other points just on the side-by-side. In the Senate version, it still has the provision on there that makes the employee's name available whenever there's been access. It doesn't require that there's been a finding of discipline. And I think Representative Hillstrom talked about the case where she was accessing somebody, and does her name become available right away? Under the Senate version, it would. And I think I testified about the concerns that I think that raises. I think there are lots of reasons to not have the name of the employee be made public unless and until there's a discipline imposed. Finally, on a small word but a kind of a big point, both of the language in the House and the Senate, it's on line 2.1 in the House and 2.22 on the Senate, add or access to in the definition of when there's a breach, and I think this should be stricken from this part of the law. The viewing or access has already been included by adding it to the definition of unauthorized acquisition later down. By including it in the definition of breach, it's really redundant. It gets confusing about what the requirements are. And so I think if the word accessed is important, then I think the legislation should be amended to have 2.14, that line say obtained, comma, accessed, comma, or viewed. So that way we're not dealing with accessed in one and viewed in the other. So I would ask that be added. Thank you for allowing me to testify. I know I was long-winded. I'd be happy to answer any questions.
Thank you, Mr. Rogan. Any questions? All right. I have a question. I mean, we've heard that we don't have audit trails in some systems, so to have this accountability factor is impossible because we don't have audit trails. To put in language somewhere around to the extent it exists, or to the extent that there's an audit trail, in the case of the DVS databases, et cetera, do you view that to have that in law would then make it, moving forward, an adverse consequence that then systems, unless they were mandated to have audit trails at the state level, would avoid audit trails for the accountability factor? I mean, it's kind of that chicken and the egg thing. If we put in, if there's an audit trail, you're going to have this accountability factor. It makes me nervous that moving forward, systems will not have audit trails because they don't want the accountability factor, if you follow me.
I do. I think, and I can't remember if it was in the A7 amendment or if it's in the language here where there's a provision in here that says to the extent it exists, or to the extent. And I think you're right that overall that somebody might sit down and say, well, wait a minute, if we don't create the data, then we don't have an obligation to do anything. So I think I certainly don't think that we're going to be making decisions on our IT and audit capabilities based on whether or not that language is in the Data Practices Act. I believe that Hennepin County would look at, we want to be somebody who can be trusted and transparent, and we're going to have audit trails because we think that that's best practices. So I don't really think that it's going to have an impact, but I understand your concern. And I think that having them both to say, I don't think that you want to have it be that we have to prove something that we don't have the ability to look at. But I'm not opposed to saying that when you look at new systems, somebody's got to take a good hard look at whether or not you can create an audit trail for this, and only in those cases where it doesn't make any sense, would we not require an audit trail? And then I think that, the other part of it is just to make sure what's in the audit trail when somebody pulls a piece of data and then it's used by a team of people. Is what does that mean? Does that mean we have to disclose and create a log for all those people, or is it just the one person who pulled it off the system, which is relatively easy because they accessed it? And if we have a computer system that's making the audit trail, that's easy. So I think that's another part of it. But I don't think that large entities are going to make decisions based on audit trails based on there being a provision in here that could, give them an out if they wanted it.
And then back to your comment about the mandatory letter of discipline, and I think that, we're really struggling with the pervasiveness of this unauthorized access. This has been going on for years. The Met Council employee, I now have a whole packet of stuff. The investigation's been complete since 2011. Access occurred 69 different times from this person's home computer. I mean, for the life of me, can't figure out why we don't have a system that limits access to pre-approved IP addresses. I mean, I just feel as a policymaker that we still don't have the accountability factor. And so, MMB was actually offline, spoke about this mandatory letter of discipline concept for the bad actors. And so what's your idea for getting at the bad actors?
Madam Chair, I think requiring, as this legislation does, the report to come back and to have an explanation done for what happened in those instances, is appropriate, and to have the disclosure. I mean, I think getting the sunlight in that way, rather than trying to force it into trying to make a particular decision on a forcing a letter of reprimand on a particular employee, is the better way to do it. And I think you can get the bad actors, or could add to the bad actors, by forcing government agencies to disclose at the end of the day, as it does in this report, we know when there have been data breaches and what was done on those, and that will create more of the data that you're looking for, that if in fact it's as rampant as you suspect it is, and governments are now disclosing that, then the legislature can come in and come up with different remedies to try to deal with trying to make sure that employers are dealing with those bad actors appropriately. I can tell you in Hennepin County we take it very seriously, and we don't, we do discipline, we have terminated people, we've done other things that are these bad actors. I don't think it's the role for the legislature to come in and try to say, no matter what, here's what you're going to get a letter of reprimand. I think the better way to get at it is to get the information back to the legislature and to the policymakers to say, this continues to be a problem, and we're now disclosing it, and you can add up all the different local jurisdictions and see how many people are accessing data inappropriately, and then come up with a remedy at that point, a different remedy.
All right, any questions? Senator Limmer.
Thank you, Madam Chair. The last time we met, I think it was last week, Mr. Gemberling was here, and he was talking about his early days working in the Department of Public Administration. He, for most people, know that he kind of specialized in data privacy and the rulemaking that went into that. He reminded the committee that when he would go to agencies, and he was the one in particular, I think, the Department of Public Safety, when he would give his instruction to that agency or department, he would specifically tell the audience, these new employees, what were the rules of engagement and what were the consequences. And he would say, you could lose your job if you do this incorrectly, if you use data incorrectly, if it's false, if it's a inappropriate breach of someone's security. And he said that was very useful because everyone in the audience wrote down everything. Everybody knew exactly what the terms of their employment were regarding the handling of this information. I'm not, with all of the advent of all of these breaches, that it just seems like it's a constant, perpetual torrent of breaches over recent years. I've casually followed it. It goes from driver license data, it goes to DNR data. It just perpetuates. Now we have Met Council reference. So it's not just state employment. It kind of is filtered all the way through. And I don't know, for some reason, some of us just can't seem to keep our fingers off of other people's data. And I don't understand that. Maybe they think it's such a casual exercise that no one will know, and there's no need to really get too serious. It's just kind of a peek over the fence. But I think we may have to reinforce a little bit of departments specifically stating you can lose your job over this. Now, I noticed on page 2 of the amendment, there's a reference on page 2.16. This is in regards to when a public employee whose conduct constituted an unauthorized acquisition of not public data, well, they must be issued a letter of reprimand. Well, could we maybe say at least a minimum that they get a letter of reprimand, and that other consequences may be triggered by this unauthorized acquisition? But I think we're being a little too casual, and I would like to see us be a little bit more specific in reference to what consequences could be, because sometimes over the years, we kind of forget that when we don't have discussions like this all the time.
Senator Limmer, I think the language allows for additional penalties.
Madam Chair, does the language direct government agencies, departments, to specifically state to their employees in their training programs that they could lose their job if they make illegal acquisitions? Just to make sure that there's a definite statement, at least, to give fair warning to employees, you cross this line, there may be severe consequences that befall you after an investigation.
Well, Senator Limmer, I know that training is required, and I'm not sure that we're so prescriptive as we
All right.
state that they could lose their job, but you'd think as a course of training that they would do that. Senator Dibble.
Thanks, Madam Chair. Senator Limmer, if you look back at Section 3 of the House or Section 4 of the Senate, page R4, it does say willful violation of this chapter. And existing law says by any public employee constitutes just cause for suspension without pay or dismissal of the public
Could you
employee.
repeat that, Senator Dibble?
Oh.
The din of construction and jackhammers drowned you out over here.
Yeah, we got the filling, rattling, grinding going on over at the Capitol, too.
Sounds like my dentist.
Yeah. So if you look at paragraph B, I'll just take a look at the House language here, there on the left, line starting with line 4.15. There is existing law that says this is excuse me, cause for dismissal.
Okay.
Madam Chair.
Just a minute. Senator Sharon.
Yes, I've been thinking this. I heard your comments about Senator Limmer wasn't here, I don't think, to hear it, so I'll just sort of summarize that your objection to the legislation articulating a consequence is that there is already in law a process of consequences, and that you think it should remain within the responsibilities of the employer to determine the consequence after investigating. My question, though, is at the point at which there is some concern about an employee's inappropriate use of their access, at that point at which that process of review occurs, are they suspended? Are they temporarily suspended at that time from continuing access to data? Or how is the employee, who is the subject of of questionable actions, misuse of authority, treated at that point in time?
Mr. Rogan.
Senator, it depends on the severity of the breach, but yes, in many instances that they could be immediately suspended with or without pay, and then or have their privileges suspended while the investigation proceeds, and then we would proceed to impose discipline the same way that we would for other acts that violate this law.
And may I
Senator
continue?
Sharon.
Thank you. And that is true that's true in your county, but is that because that's a policy that you've established within your system, or is that do you know if that's a generalized approach?
Mr. Rogan.
Madam Chair, Senator, I think it's more general. I mean, this comes into much more of what has been negotiated and what the terms are of employment. But in general, and specifically in Hennepin County, when we have noticed that somebody has violated the law, we do an investigation to determine what discipline should be imposed. And oftentimes, we will suspend the person immediately from doing their job so that we can do the investigation, but protect the public and protect ourselves, frankly, from making sure that person doesn't have access to doing their job while we do the investigation. And then, if it's severe enough, and they're terminated, they may never, have access again.
Thank you, Madam Chair. I'll just follow up one more. I really am aware of what it is that you're trying to address here, and the conflict in the goal of articulating from the legislature our seriousness about this by your language that you proposed here, in light of should you have the employer make those determinations or should the legislature, and then Senator Limmer's discussion as well. It strikes me, because I'm listening to this in light of the fact that we're looking at this in relationship to licensed health professionals as well in another committee in another place, that when somebody has access to information, or like in healthcare, can introduce themselves into the lives of vulnerable people. The public here is vulnerable because of the information that is held by the government in this case, or any business for that matter. That I think that it's right for us to challenge the idea that we do not have the right to expect a minimum response from everybody that has public data, private or public, to deal very, very explicitly and clearly that it's a boundary violation and that we have language that articulates that. So I'm not as sympathetic to that argument in the cases where somebody is given the authority to have access to private information. That's a real privilege. That's a real right. And that the ethical standards that have to be held by that organization in regard to that should be very high. And that if we need to strengthen language legislatively to make certain that's happening, I'll support you in that. So.
Well, thank you, Senator Sharon, and I think that's part of our frustration, and I don't think I have the document here with me today, but there's a whole range from a slap on the hand to termination, and there's no continuity. And quite frankly, I think I've been at this 5 or 6 years now trying to build some accountability. This latest Metro Transit employee was not identified by the audit function of DVS as an extreme user. Like the DNR employee, it was a result of another investigation. In the case of the Metro Transit employee, they were going back and circling around with people that they had identified as having a problem. They had retrained them and were circling back around after the retraining to see, what they were doing, and saw that even after retraining this particular employee, did not clean up their act. And so it's just extremely frustrating. And they didn't like the A6 amendment. You sat through that unpleasant experience of a mandatory disclosure, so we took the other approach of a mandatory minimum level of discipline. We don't say how long that letter of discipline has to sit in the file. We don't. I mean, it's like just a very minimal trigger, and then what it does trigger is it triggers disclosure, because if there's discipline, then there's disclosure of the bad actor. And how do individuals who give their information to government know about the bad actors if there's not disclosure? And that's the crux of the problem here. And I mean, we're searching for a resolution here, but
One follow-up, please.
Senator Sharon.
I'm reacting also to Senator Limmer's discussion about what is the communication on the front end about that when you're given the privilege to have access to people's information, that what comes with that privilege is clear boundaries and ethical standards, that if you violate them, there will be serious consequences. That communication has to be quite explicit, not soft, not sort of somewhere along the line somebody finds out what the consequences are. So I think what Senator Limmer was talking about, it doesn't address this, when can you discover who the actor is and stuff like that, but when I'm listening to this conversation, it reminds me so much of the dampening down in the protecting of the system and protecting of the players in the system, and forgetting about the importance of who is the victim in this process and how do we strengthen because I don't want to, I really believe that the collection of the data and having data helps us achieve really important social responsibilities. And I think we need to continue to be able to do that, but without raising our consciousness and those who have this privilege to have access to that, to the consequences of violating the standards. So I'm just responding to the particular portion of the testimony that says government shouldn't get into defining some of what public-private entities who gather data's response should be to somebody who violates that boundary.
All right. Senator Dibble.
The risk of piling on, as long as we're giving our speeches.
I'm sorry, I'm passionate about it.
Yes. So, Madam Chair, I'm just echoing the frustration, I guess. I think you've been working very hard, and I appreciate it, trying to find a creative solution. And, I think failure for public entities and public agencies to partner with us defeats your purposes, defeats our shared goals. Clearly, we're at a point already with the public of a total breakdown in trust because of these sorts of experiences, because of the acquisition of ever more effective surveillance tools, the automatic license plate reader, the Kingfish technologies, without a thought to informing the public that these things are being used, much less any thought about how the data that's acquired is well managed. And then when we come forward with some ideas, a retrenchment, protection of the prerogatives of bureaucracy, et cetera, and we see the response and the reaction on the part of the representatives of the citizens is to go ever further and ever more aggressively attempt to rein in the irresponsible use of the data because trust is breaking down. And I would just say to members of the audience who are representing public agencies, it is in your interest to step forward with good ways to solve this problem because it's not going to go your way in the end. I don't know if we're going to solve these problems today. Time is short. We've got all kinds of resistance. But you've seen the votes on the floor of the House and the Senate. The legislature is poised to severely clip your wings and your ability to have continued access to data in ways that you say you need them to do your jobs. Continuing efforts to resist creative solutions is just going to result in the opposite of what goals you're trying to achieve here. I appreciate the creative input and the feedback. I'd say this is a good example where, sure, Met Council did some things right. They did some training. They communicated clearly. I've read this packet. They communicated to folks, we don't want to be in the newspapers. Be responsible. The guy who did this accessed over 7,000 records. 7,000 records. And they only figured it out weeks or months or years later. So, they tried to do some things right, but clearly something broke down. And these are the kinds of this can't happen. It's the proliferation and the casual attitudes, and people say there's only a few bad apples. The legislative auditor's report shows something quite different. That it was in some of these databases, especially driver's license, very casual, very loose. Lots of people just dipping in, taking a look, writing their Christmas card list, you name it. As soon as there was bad publicity and adverse court cases, things started tamping down. But are there fundamental structural differences that have occurred since then? No, it's just because there's some pressure right now. I think that's kind of a temporary effect of all this scrutiny and all this media attention and all this legislative antagonism towards this behavior and this activity. We need some systemic solutions, and we need some creativity coming to the table, and not all of this resistance and adversarial conversation. Something went wrong here. And guess what? That council ended up in the newspaper, or at least on Channel 5. So, I'm frustrated. I don't know what to do at this point. I don't know that we're going to get to an agreeable solution today, but we have our commission. Something's going to happen.
All right.
Madam Chair?
Representative Hillstrom.
Thank you, Madam Chair. And Senator Dibble, I appreciate your comments, and I really think that the commission is probably the place to get to the details of what the tracking system should look like, how people should audit. There are very few people in the legislature that have tremendous expertise in data practices or an interest in gathering that expertise. And so I'm actually really looking forward to that commission to actually have the interest and the depth of expertise to actually figure this out. Because I don't think there's one person in the legislature or in public employees that want people to be able to access data inappropriately. They don't want the public's trust to be breached. There are some people that are doing it, but I think they want to have the safeguards in place so that people know it's not that way. So I really think that many of these issues should be looked at over time through this commission.
Representative Ortman.
Thank you, Madam Chair. I think we also have to balance what we're asking local units of governments to do. You know, when I think about my local police in Brooklyn Park, or I think about my county government, we spend a lot of money on these agencies, and I want the focus of their time to be spent doing the work. And, you know, some of what we're proposing would have them tracking more data on what employees are doing and spending more time on dealing with inquiries from the public about when their data was accessed and why, than I think is reasonable. I think we have to balance the fact that they do have public responsibilities to take care of, and they do have work that they need to do. And if we, you know, weight this balance too much towards the side of investigating to the end every issue that's ever raised, and taking a lot of time to track every single access of data to make sure every single time data is accessed that it was proper, we might be weighting the balance too much to what the public entities are supposed to be doing with their time to a point that's impractical. And I think there definitely should be consequences to people who wrongfully access public information, or information on the public. But I think we have to be really careful, and I think we have to take the time through a process like the commission to do it right and not to do something that is unworkable for our agencies.
Thank you. Senator Limmer.
Thank you, Madam Chair. I don't want to belabor this too much, but as I've been looking over this bill in response to trying to react to unauthorized access to data, I've noticed that we're going to put our security in this bill, thinking that, well, let's not think that we're going to solve all of the problems on this issue today with this legislation. This will continue to dog us, I'm sure. The point that I wanted to make is that with this proposal, we're focusing all of our attention on one singular bad actor in an agency and hoping that the agency responds. But I think we're kind of missing a little bit, and there's no need to get into it in this piece of legislation. But there comes a time when the agency, the supervisor who's overseeing this employment practice will have to be brought into the responsibility factor as well. And we aren't really addressing it in this bill. We are hoping, and we know that we have excellent people in our bureaucratic divisions of government. But if there were repeat problems, perpetual incidences, I think we're now getting more on a global scale, seeing more repeat incidences all the time. But we kind of focus all of our attention on the one singular bad actor. And I think maybe we may have to go back and expand this a little bit for, I don't know if it's remedial direction to agency heads, but if there are problems that I would see on any type of repeat basis, then we have to climb up that corporate ladder again and find out what's going on in the training, what's going on in the supervision, and we aren't really addressing that in this bill. But Senator Dibble and I agree on the focus and the intensity of this issue, along with Senator Sharon, that we take this issue very seriously when there is breaches, unauthorized access. This is a brave new world. It's been around for about 30, 40 years, but the technology is pulling us so fast, quantum leaps ahead, we find that we struggle in trying to catch up to it. But we need to get our focus a little broader and wider, I think, in the future to determine, is it just that one actor, or is it somewhere in the is it more systemic that we're allowing this access all the time?
Well, and to that point, Senator Limmer, as we, heard all the feedback on the A6, we're going to hear similar resistance on the A7. Today, when I challenge these people one-on-one, they say, well, we don't want to protect the bad actors. But when we as policymakers try and bring forward legislation, I don't think a mandatory letter of reprimand is unreasonable. I don't think that's unreasonable. I don't. And we've been working on this for a couple of years. I know that you like, the commission. But some of these things aren't that hard. And the reality is that we have to change cultures. And that's what, kind of your point is. But it's obvious that the actors haven't been able to change the cultures on their own. Because it just keeps happening. Senator Sharon.
And just to follow that, the concept I'm talking about is a systems accountability rather than just the one person that did this, of course, should be held accountable, but the supervising person over that person who was not aware or not training those persons to hold to certain boundaries, where's their letter of reprimand? What I think Senator Limmer has said is to really get after this, you can't just focus on the bad player. You have to hold the system accountable for not having systems in place. And if they can't have the technology now, what's the alternative? And it doesn't mean you have to have everybody tracking everything, spending all their time doing paperwork. It's that there are people that are in the system responsible for this because the public's interest is strong in being able to trust that when we give this data that it's not going to be misused. Because we need the data to accomplish really important social responsibilities and goals. So, add a reprimand for the supervising person and then their supervisor, because if there are alternatives other than we wait for the time and the technology to be developed, then they've got to be in place. I think that's the message we have to be sending here.
All right. Mr. Rogan, did you want to add anything else? And a show of hands, how many more people want to testify this morning? All right. Mr. Rogan.
Madam Chair, just 2 points, I think, in response, I think, to what Senator Dibble and Senator Limmer were saying. I think, my opposition to some of the provisions of the A7, I don't want to be taken as my opposition or Hennepin County's opposition to what the legislature is trying to do with the bill here. And I think there are things in here that, as I said in the beginning, that as an advocate where I'm going to be litigating these things, that if I take that hat off and look at the public policy part of this, there are provisions in here that I think reach some of the things that you guys were just talking about without having to get to the letter of reprimand. The fact that breaches are going to have to be reported by local government, which is the main provision of the underlying bill, is new. We haven't had to do that before. The inclusion of a report that gets to what happened, how many were done, if there was discipline imposed, who was the employee, if not, why not, is significant. That's significant sunlight that over the next several years is going to the extent that there are significant breaches, is going to look bad. I can tell you that my Hennepin County commissioners are not going to want to see reports come out that say that for the 5th year in a row, Hennepin County leads the state in data breaches, and there's going to be accountability up the line because of that. So I think the provisions in here do a lot of what the overarching goals that you were just talking about, many of you. So I think that's important. I think one other thing that in response to what Senator Limmer was saying about training, a lot of agencies do a significant amount of training. The Department of Human Services requires people who have access to their systems to have yearly training. It's computerized training. It's very specific. And in Hennepin County, we've had training, and we have just mandated that by the end of May, every single employee in Hennepin County will go through mandatory training and sign an agreement that reaches many of the things that Senator Limmer was talking about, that end with an acknowledgement that says, I understand that if I breach the terms of this agreement or state law, I can be disciplined up to and including termination, and I can be prosecuted. So I think that there is a partnership. I don't think that local governments are want to be in a position where we're trying to skirt this issue. I think there is partnership. I just think that some of the provisions of the A7 amendment I have concerns with. But I think where this is going and with the commission, I think that we are in an area where governments need to continue to be to work at how to manage access to this so that we can ensure that there's public trust in not only state government but local government as well. Thank you.
Senator Dibble.
Madam Chair, thank you for pulling this out because I recall seeing it when I went through the packet. So Mr. Johnson at Metro Transit went through the same training and signed the same, and it still happened. So something's not working.
And just one last comment, if you may.
Senator Sharon.
Root cause analysis isn't just of the person who did where the act happened. A root cause analysis is of the whole system. So maybe there's something in this language that we can put that when there is a breach noted, that it isn't just an analysis of the person in the breach and they have the consequence, but an analysis of how the system failed to be able to protect the responsibility of the agency protecting public data, which goes all the way up the line. So,
Thank you. Thank you, Mr. Rogan.
Thank you.
Welcome to the committee. If you'll state your name for the record, please.
Thank you, Madam Chair, members. My name is Carrie Steenblack, and I'm the Assistant Commissioner of Individual Taxes at the Department of Revenue, and I'm here to talk about the A7 amendment on behalf of state agencies. Before I start, I do want to emphasize that we understand and support the importance of appropriately accessing data that we are entrusted with, and we support holding employees accountable for inappropriately accessing information. In today's world, there are several things that occur in reference to protecting the data. There are policies that incorporate procedures governing access to the data if sharing the data with other government entities. We also have procedures for ensuring that not public data is accessible to persons whose work assignments reasonably require it. And so what that means is if somebody does not have a business reason to have access to a certain system or certain data, we restrict that piece of it. And that is something that is also currently evaluated by the legislative auditor as well. As part of new hire employee orientation, employees are told that their job depends on it, that they should not be accessing information without a business reason, and if they do, there will be consequences to that. There is regular disclosure training that happens on an annual basis where employees are educated on what the appropriate access is, and there is a check for understanding that goes along with that to make sure that they understand what appropriate access is. And then finally, there are code of conducts in place that talk about the accessing of data as well. So again, we are supportive of making sure that we're protecting the data that we're entrusted to have access to. With that being said, there are a few points in the amendment that we would like to discuss. On line 1.5, it states if the individual or subject of private data believes their information has been accessed. Having a hunch or a belief is very broad and lends itself to frequent challenges. In the last conference committee, the Assistant Commissioner of MMB, Ann O'Brien, testified to some of the issues agencies have with hostile individuals. The individuals that threaten agencies and staff could be the same individuals that are making frequent and frivolous requests, making it difficult for the agencies to administer this law and taking away from the core responsibilities of the agencies. So our recommendation would be that if the term believes is used, it is further clarified to make sure that there's a clear understanding of of what that means and when somebody can access or request that information. On line 1.21, it does require a response to the request within 30 days. A 30-day time frame may not be sufficient in order for us to appropriately and sufficiently respond to somebody. Investigations often take longer than 30 days to complete, and we need to conduct a full review of the individual's information. This includes determining what was accessed, when it was accessed, how it was accessed, and what the business reason is. And with any investigation that is done, employees have the right to be interviewed and share their side of the story. And we also want to make sure that we're thoroughly interviewing witnesses as well, or somebody who may have additional information into those accesses, to be able to determine was the accesses appropriate or inappropriate, and why, to make sure that we can take appropriate actions. So we're concerned about the 30-day time frame and would recommend evaluating that time frame.
And how many days would you like?
Each situation, depending upon the number of people that have accessed it, depending upon the length of time, I don't know that I have a specific time frame. I hate to use the term reasonable, but reasonable time frame.
All right.
Line 1.2 requires us to provide a justification by providing the purpose for the
Madam
access.
Chair?
Senator Limmer.
Could you tell me what page you're on? I'm having difficulty following.
The amendment.
Is this on the amendment?
This is on the amendment, yes, the
Page
87 amendment. Line 1.22 is on page 1 of my copy.
Okay, thank you.
And this requires us to provide a justification by providing the purpose for access. And this is concerning for several reasons. Some of the reasons for accessing the data is confidential. For example, we talk a lot about law enforcement agencies having that information restricted, but state agencies may not have law enforcement personnel, but we have informant information, criminal investigations that are done by non-law enforcement certified personnel, or audits that occur. Disclosing why an individual was accessed could increase the potential for fraud and jeopardize our ability to conduct our work on behalf of the state. And I know within the Department of Revenue, the audit criteria, there is a statute that indicates that the audit criteria cannot be disclosed. So disclosing the why here feels like it's in conflict with that. If we provide specific details to the individual as to why their data was accessed based on the inquiry from them, this would be a large administrative burden, and I want to talk a little bit about this. So I'm going to use the Department of Revenue as an example here. I'm concerned about the realistic expectation of being able to do this. When I look at the paper piece of it, last year the Department of Revenue received 2.7 million pieces of paper, or 2.7 million letters were mailed to us, and most of that information is private data. And what happens is the information comes in a standard envelope, and because of the age, we're no longer in the paper age. We've transitioned, and many agencies have transitioned to electronic processing of things. So when that paper comes in, we have to open that envelope, and somebody is responsible for then unfolding it, flattening it, removing staples, taping the pages together. That's private data. And so those 2.7 pieces of mail that are coming into us, in interpreting the law that's here, we would be required then to have some type of log that would track that they accessed that information, because somebody may ask for it and they may ask for the why. And so as we're processing those letters and opening them, one person or whoever's doing that would be responsible for that. When that piece goes to be imaged and attached into the system, another person is running the scanners, and there's a screen that's in front of you, and all the images are coming in front to make sure that they are being appropriately captured. That person as well would then be accessing this private data and would be required to then have some log as to why it was accessed in the event that we were asked for that. And that process continues. And so we don't keep the paper. We keep paper long enough to know that we've captured the information electronically, and then we destroy it. However, during that time frame, we have a large amount of paper. So this would add to us keeping additional paper, or on the back end, going back and taking these logs and scanning them and implementing them into the system. And so that could be a little bit burdensome, and it could delay, it takes people away from their jobs of opening and scanning, and they're spending time tracking, which could delay refunds or money put into the coffers. So there could be some delays associated with that because of the volume of paper, and we're not the only agency that has that kind of volume. So, and again, the reason why we would have to have a log, as I mentioned at the beginning, people that are opening this, they don't have access to the system today, nor do we want them to have access, because there is more information in the system than what they need to do their job. So that's why we would have to implement a new administrative process to track this information so that they aren't accessing the system and accessing information that is not needed to do their job. We do have to program the systems to track the why. There, in the amendment, there is no limitation to the time frame. Someone could request the information. So in order to be able to tell somebody why the information was accessed, we would need to have a way to track that. So depending upon the length of time, it's more difficult to reconstruct it if we're not tracking it now, because of the multiple functions that occur across state agencies or employee turnover. We do use some commercial off-the-shelf products, and we rely on vendors to make custom programming. I'm not a yeller, but I feel like I'm yelling at you right now. But to make custom programming to systems in order to capture the why. Many of our products are off-the-shelf, and they're off-the-shelf products because they offer the current functionality that we need in order to do our job. They also are more cost-effective. And once you start customizing those, there are increased costs associated with that, and also some increased risks. And many vendors are not interested in customizing their product for the benefit of one state. So it's just, again, something to be aware of as you're looking at those that use vendor products. Information can be accessed via programs not built for tracking. So, for example, Excel spreadsheets, Access databases, or analytics software queries. Establishing a process to track the why and storing all the data would be cumbersome and expensive. I also have a serious concern that this could increase the risk of possible future inappropriate accesses. So in today's world, we may partner with other agencies in order to do our jobs. And what we may do is we may send like an Excel file to them with private data in an encrypted manner. And part of the requirement that we have to make sure that data is protected is once they've done the piece that they need to do, that they destroy that data so that it cannot be accessed by somebody down the road inappropriately. We're concerned that this legislation would require us to retain that data in the event somebody believed their data was accessed, and it would also require us to document the why. So that file would need to stay around longer, which again could result in the potential for a future breach. Finally, in this section, the language is not clear. It says in a manner not authorized by law, but it doesn't help the person inquiring understand what not authorized by law means. So, you know, there's a little bit of a concern that an individual can send a letter at any time and they may feel like they've been accessed inappropriately, but there's nothing to reflect that the data has been, and no clear understanding of what not authorized is. So we would just recommend if we leave manner not authorized by law, we define that or align it with other terminology in the agreement. Also, as I mentioned earlier, there is no time frame in place, so individuals could request this on a weekly, monthly, annual basis. Again, there are individuals that will use this as a way to make frivolous requests to the agency and distract the government entity from our primary job functions. Line 2.5 talks about unauthorized acquisition, and the term acquisition could imply that it's taking of the data when it may be somebody who's looking at the data but not necessarily taking the data. So we would recommend clarifying that piece. And then finally, line 2.6, this is the area that talks about the discipline. And again, I do want to reiterate that we do take this seriously and we are committed to appropriately disciplining employees. If we determine that there is a possible issue, the system access is immediately removed from the employee, and the employee may be put out on paid or unpaid investigatory leave. And that's a practice that is in place today within state agencies. The concern we have is that this language is a little bit too prescriptive, and quite frankly, we may want to do something more potentially, or, you know, and by saying in here that the individual must be issued a letter of reprimand for that content, we believe that there may be, it's too restrictive, and it may only allow us to do a written reprimand, or we may have to start with a written reprimand, whereas we may want to start with a different type of disciplinary action. So we would recommend making that a little bit more generic. If there is a determined unauthorized access, then disciplinary action must occur, or something along those lines.
Ms. Steinbuck, I'm not understanding, given that it doesn't, we have in there provided that the letter of reprimand does not prohibit additional penalties allowed by this section or other law related to the conduct. That doesn't give you enough latitude to do more than a letter of recommend?
Madam Chair, members, a lot of times penalties are taken to mean like a civil or criminal and not necessarily an employee discipline. And so we're concerned that it is too prescriptive, and it would lead potentially employees to think that if they access it, it's going to be a written reprimand. And it may be something different than that depending upon the situation.
Thank you.
Line 2.30 and 2.32, we did have some concerns, but we've already covered those earlier. And so, again, I'd like to thank you for your time and reiterate to you that we do take it very seriously, and we want to make sure that it's used appropriately. And with that, I would stand for any questions.
Thank you. Ms. Steinbuck, you said you were speaking on behalf of the agencies. I had a conversation with Mr. Pollack at MMB, and he said that MMB would be supportive of the mandatory discipline and the subject's right to challenge access as concepts. So are you saying that MMB has one position and the rest of the agencies have another, or?
Madam Chair, members, we're not opposed to disciplinary action if there is an unauthorized access. Again, we're just, as the language here, as we mentioned, it's a little too prescriptive, and we want the flexibility in the event. We do believe that employees would take that as it would be a written reprimand, and it may be a different type of disciplinary action. So we would want the flexibility and the ability to do what's appropriate for the incident that we're dealing with. And we're open to the others as well. We just believe is a little too generic or vague, and we're concerned about frivolous or issues
Frequency
coming
issues.
forward.
Yep,
So.
I get that. Any other questions for Ms. Steinbeck? Are you here on behalf of MinIT as well?
I am not. I am here on behalf of the business I don't know enough about technology to share, other than I know we would need to do some changes to the system, and that would be concerning. But from a cost standpoint or what that would take, I don't have enough to know that.
All right, thank you. Anybody else want to testify? Welcome to the committee. If you'll state your name for the record, please.
Madam Chair, members, my name is Tom Grundhofer, General Counsel for the League of Minnesota Cities. Thank you for hearing me today. First, let me stress the issue of improper access is a huge deal for our cities. We run an insurance program for cities, as do the counties, and we've already spent quite a bit of money working on this issue and paying defense dollars and that sort of thing. So don't take my comments in any way as not being understanding of what you're trying to do here today. We've spent thousands of dollars on training. To date, in the last about year and a half, we've probably trained over 3,000 peace officers in the state of Minnesota on the issues of proper access. Again, the point that we are very serious about how we're dealing with this. But that said, the A7 amendment concerns us from a process standpoint in a couple different ways. We're not adverse to looking at a different process, but we're concerned about the process that you've talked about in A7 is creating some problems. It's already been alluded to that while there's not a specific audit trail or documentation requirement in the A7 amendment, the way it's written, in effect, creates a huge audit mandate for local governments because of the need to be able to defend themselves against claims that there's been improper access. So that will be a very costly item, the documentation and the audit requirement. The other thing we have particular concerns with this particular process is the fact that somebody who's aggrieved by the investigation that's done in the local level has the right to a contested case proceeding. That's also another huge financial mandate because the way that particular contested case language talks about local governments or whoever has to be involved in that has to bear the entire cost of the administrative proceeding under this proposed process. So the process you've talked about does, I think, create a pretty significant financial mandate on local governments. And again, I'm not saying that a process isn't appropriate, but this particular one creates some significant costs. The one that I would suggest, and the individual from Hennepin County did talk about, we already have in the data practices law a fairly recent administrative process for going to the Office of Administrative Hearings for people who feel that there's been noncompliance with the law. If we were going to kind of build in yet another administrative process into data practices, I think the best place would probably be to try to put it in the existing OAH process that already exists. I think that has a couple advantages. Number one, it's already there. OAH is already in the business of kind of administrating data practices challenges. It also has it deals with the time look-back issue. The way the process you have in the A7 amendment deals with, there's an unlimited look-back, and frankly, that's pretty scary to local governments. The 085 provision that's already in this data practices law has that 2-year statute of limitations look-back, and I think that would be a nice accommodation and wouldn't quite be as scary for local governments. So with that, again, we're very supportive of the efforts. We're not opposed to many of the core elements in the underlying bill. We're just very concerned with the process that's talked about in the A7 amendment, and so I would certainly answer any questions.
Thank you. Well, the administrative process is a $1,000 fee, and for somebody who looks at a run of the access to their motor vehicle or driver's license records, and we've given the example of, I've never been to Baxter, Minnesota. I can think of no reason that anybody in Baxter would be looking up my information to pay $1,000 to find out why Baxter law enforcement was accessing my record seems a little unreasonable to ask of the general public.
You know, Madam Chair and members, I was kind of involved when that language was put in a couple of years ago, and frankly, it was a bit of a balancing, because what you're dealing with in the 085 process is an opportunity for either side to go and kind of go to the Office of Administrative Hearings. And people can take this administrative challenge, and even under your proposed process, can take it and lose their challenge. But in the meantime, the local government ends up paying $20,000 or whatever the amount is to defend themselves against what ultimately is proven to be an unacceptable challenge or unfruitful challenge. So I think the existing 085 language was put in there acknowledging that sometimes these challenges don't necessarily result in being upheld. So
Representative Hortman.
Madam Chair, I hate to leave, but we have caucus that's been going on for 35 minutes, and I have a bill up on the floor today that I would really like to pass. So I'd like to explain to my colleagues why they should vote for it in caucus. But I think that the amendments that have been brought forward in the conference committee have really meritorious ideas. And I think that what I'm hearing from senators in particular and the House chair is that we need to do more for individuals. And I don't disagree with that. I just think this language in the A7 amendment and what was proposed earlier in the A6, if it went through the House, would have gone to civil law, GovOps, state government finance, potentially judiciary finance, and we would have had time to work through all these things. And I realize we're the smartest 6 legislators, and so possibly we could do the work of all these committees, just the 6 of us. But I'm concerned that we have really good policy in what was House File 183, the base bill that passed. And I think the Senate floor amendment definitely raised these issues of individual rights that we should look into more deeply. But given that it's May 8th, and our speaker gave us a directive in caucus yesterday to try to close up our conference committees by noon tomorrow, if we expected our bills to become law, I think we might, in our pursuit of the perfect, be the enemy of the good here. And I don't want to see House File 183 not become law, because we're concerned about providing additional protections, and we can't quite hit the nail on the head to get that done in this place. So before I dart it off to caucus, I just wanted to say I think we've got good work here. We have more work to do in the future, for sure, and I'm supportive of that. But I think we should consider moving forward on a proposal we can get through the conference committee and both bodies before adjournment.
All right, thank you.
And with that, I'm going to run off.
All right, thank you, Representative Hortman. Are there any additional questions for Mr. Grunhofer? All right, thank you. Anybody else in the audience want to testify today? All right. Is there anybody from Min IT here? Oh, lucky you. I have a letter that was sent by State Chief Information Officer Carolyn Parnell that expressed some concerns with the A6 amendment for implementation and the audit function, et cetera. When we brought the A7 amendment, we were silent on effective date of the new language in the A7 amendment. Do you have any draft language or any ideas on how to address state agency IT upgrades issues that would conform to a standard that you'd be comfortable with, that would move us in the direction of more accountability without putting an undue financial burden or affect your contracting timelines and procedures currently in place?
Madam Chair, members, I did hear your comments earlier in the hearing that you would like to hear from Minute some idea of an implementation timeline for the mandate, as well as maybe an RFP issuance date.
Could you state your name for the record? I'm sorry.
Apologize. John Eichten is my name, legislative liaison for Minute Services. So I did put that request out to our cybersecurity team. I'm sure you know Chris Boozy is our Chief Information Security Officer.
some of the questions initially that came back were, I suppose are initially around the RFP, what type of RFP would be envisioned. As we read the mandate, we would be looking at some serious retrofitting, if not replacement, of databases, applications that work with non-public data. In the state portfolio, we estimate we have around 2,000 applications. There would be some fairly significant retrofitting that would have to occur, again, if not replacement.
Sir, I guess what we're asking is for you, recognizing that you're supposedly the experts in this area, for you to provide information moving forward that you could work within. We're not saying our language was perfect. In fact, we failed to provide an effective date in the A7 amendment, recognizing that we were not the experts in this area. So what would be more helpful, rather than commenting about the problems, for you to come forward with some solutions, recognizing that the legislature is committed to more robust audit functions in state systems, and how you can accomplish that in a time frame, and what type of standards or legislation you could work under to assure that that would happen.
And, Madam Chair, I was just attempting to relay the magnitude of the analysis that would be required to even answer that question. We reached out to some folks out in the industry about, what would the first step be to look at requiring essentially record access awareness across the executive branch in systems containing non-public data. Initially, what we're hearing is we would need to spend at least, as was indicated in the A6 fiscal note, at least $1 million off the bat just to study the issue and look at what systems would need to be replaced, what off-the-shelf software could we essentially bolt on to existing systems, or what systems would not even be compatible with that off-the-shelf software to be able to track record awareness on the individual record level. That doesn't get at the purpose of access, which is something that you can't really automate, so it requires some level of narrative information to be entered along with each accessing, so that could later be looked to for auditing purposes. So our initial suggestion would be that we study the issue, that we work with folks out in the private sector to look at what would be the most effective way to ensure that our systems are set up in a manner that we can track, we can audit access of data. Some of the newer systems that we've set up do have this capability, but the fact is there are legacy systems, decades old, that would take significant work, and we feel that we would need some time to do analysis to even estimate with some reasonable level of accuracy the amount of costs that would be entailed in meeting that mandate.
Senator Dibble.
Thank you, Madam Chair. Mr. Acton, that presumes the A6 language is still operative. Looking to the A7 language, looking prospectively as systems are, as legacy systems are retired and new systems are brought online, what would Minute's reaction be to making sure that this level of functionality, this kind of functionality, is a standard practice?
And, Mr. Chair, I didn't read the amendment, the A7 amendment, that way. In fact, the way we read it was, instead of putting the mandate to 2020, it would actually be immediate to the effective date of the legislation. The way we read it, it's
right.
all cybersecurity.
Senator Dibble.
Let me rephrase. What would Minute's reaction be to looking at this idea on a prospective basis as legacy systems are retired and new systems are brought on?
Mr. Acton.
Mr. Chair, Madam Chair, Senator Dibble and members, we would be much more open to that. We still have concerns about the extent to which that would limit our use of some of the cloud-based systems that exist that may not have this individual record access awareness tracking functionality. That's something, again, we would like to have some time to look at through perhaps a study, but we're much more open to the mandate on new systems as opposed to retrofitting existing systems.
Senator Dibble.
Mr. Reichten, would even that be $1 million study?
Mr. Eichten.
Madam Chair, Senator Dibble, I can't say at this time how much it would cost to study that. I would expect it would be less than $1 million to look at what the impact would be if all new state systems were required to track access of data on the individual record level. I would expect less than it would be to study that for all systems.
Any additional questions for Mr. Eichten? All right, thank you. Anybody else in the audience like to testify? All right, I think what we'll do at this point is go into recess. The floor House goes into session at 10. Senator Dibble and I will take some time to have some discussion and see where we think we can take this. So the committee's in recess.